See, to seek condonation of delay from the court, the major essential is to satisfy the court that there was sufficient cause for the delay. Now the question arises, if there is any subsequent change in law, so can it be understood as a sufficient cause for the delay in filing? The answer can be yes and can be no, and it will depend upon how the facts are presented to the court. So in a recent 2024 case, Delhi Development Authority versus Tejpal and others, the Supreme Court ruled that such delays cannot be condoned on the basis of any subsequent change in law. But after a thorough analysis of the ruling, it can be said that the decision could have been otherwise also. Further in this video, I will also highlight the big mistakes by the lawyers because the way the facts was presented to the court didn't fulfill the essentials of the law. So how the facts would have been presented, I will also highlight this in this video. So now the relevant provision of law is section 5 of the Limitation Act, which talks about the condonation of delay. Most people read this provision very casually, ignoring the last 3 words. Now that phrase is within such period, that means within the prescribed period of limitation. Now Supreme Court took this phrase very seriously and went deep into it, and because of this, the party lost a winning case. So what was the facts of the case? So because this case pertains to land acquisition, the facts are quite complicated. So for better understanding, we will take an example. For example, a person has to file an SLP, that is a special leave petition, before the Supreme Court. So the time limit for filing the same is 90 days from the date of High Court order. But the person did not file the same within 90 days because the law was against him. And not even the law, the interpretation of law by the Supreme Court, which in itself is a law, was against him. So he didn't file the same because he knew that the result will be futile and against him. So he refrained himself from filing the same. But subsequently, after 5 years, a larger bench of Supreme Court felt that the previous interpretation of the law was wrong, thereby overruled the previous judgments and settled a new law, the new interpretation and understanding of the law. Now that new understanding of the law regenerated the right of that person to file the SLP, regenerated its cause of action. So now the question arises, the person has a cause of action, the person has a right, but the limitation period was of 90 days, which has expired. But the interpretation of the Supreme Court was also wrong. Now it is right. So can this subsequent change in law is a sufficient cause for condoning the delay? So what Supreme Court observed? So in this case, Supreme Court referred another Supreme Court ruling of 1981, Ajit Singh Thakur versus State of Gujarat, and confirmed that sufficient cause is an event or circumstance which happened within the limitation prescribed period, which led to the delay. So if the period is of 90 days, there should be an event within those 90 days. If there is any event or circumstance after those 90 days or after that limitation prescribed period, that will not constitute a sufficient cause as per the law. And what the facts were presented to the court, that after 5 years, there was a subsequent change in law which gave a cause of action. So actually what happened is after 5 years, and nothing prevented them within those 90 days. So this fact does not meet the essential of the law. Law wants what prevented them in those 90 days. So the facts could have been molded like this, which is true also, that within those 90 days, the person who wanted to file the SLP went to an advocate. The advocate suggested him, advised him not to file the SLP because of the previous erroneous interpretation of the Supreme Court of the law. So the previous wrong interpretation of the Supreme Court led to the wrong understanding and decision of the litigant. Had the previous interpretation of the Supreme Court be correct, the litigant would have filed the SLP within the prescribed limitation period. So what prevented them to file the SLP within those 90 days? The wrong legal advice based on the wrong interpretation of the Supreme Court. And that wrong understanding of Supreme Court of the law continued to prevent them till the correct interpretation. And the moment it came to the knowledge of the party of the correct interpretation of the Supreme Court, they are filing the SLP. So this way, the essentials of law could be met easily. Anyhow, let us see what Supreme Court observed further. Supreme Court observed that if the subsequent change in law would be allowed as a sufficient cause for condonation of delay, it would open a full Pandora box and a floodgates for many cases, because the cases which were already finalized will reapproach the Supreme Court with any further subsequent change in interpretation. So this way, no proceedings will reach its finality. Further, Supreme Court held that the overruling of a decision only takes the power of its binding nature as a precedent and does not overrule its decision in a litigation. Even if a decision of a court is erroneous and wrong, it will continue to apply. But Supreme Court also added at the same time, if during a litigation there is a subsequent change in law or the interpretation of law, the litigant will get its benefit. But if after the litigation there will be any subsequent change in law or the interpretation of law, litigant will not get its benefit, because the proceedings will be over and achieved its finality. So now this Supreme Court ruling of 2024 Delhi Development Authority ruling has raised a very critical and thought-provoking questions that remain unanswered. Firstly, if a person has suffered injustice due to the wrong interpretation of a law by the Supreme Court, and the court subsequently corrects its interpretation, and that person approached the Supreme Court for getting justice, so should that person be denied justice on the technical ground of limitation, being the fact that injustice can be rectified and justice can be restored? And it raises further question also, what is the priority for Supreme Court in such cases? Doing justice at any cost, or avoiding the floodgates to open at the cost of allowing the injustice to perpetuate? And further, Supreme Court ruling raises a big question that does, apart from law and reasoning, there is a luck factor also in the decisions of Supreme Court and in the winning and losing of a case. Because if during the litigation, if there is any correction of the interpretation of law by the Supreme Court, then the party will get justice. But in case the proceedings achieve its finality and thereafter the law is changed, then the party will not get justice. Further, do you know, today about 90% of the cases in Supreme Court get dismissed on the very first day of hearing. But doesn't this ruling gives one more ground of appeal, that even if the case is not maintainable at present, it should be admitted and kept as pending, because there may be any subsequent change in law, and with that the litigant will be benefited. And by this way, it will open even more floodgates, because everyone will file a special leave petition even if the case is not maintainable, because there is always a chance of subsequent change in interpretation of law. And also the advocates now give their opinion based on the current law of the land, that is the current interpretation of the law. But then the lawyers will also suggest to file the SLP even if it is not maintainable, because there may be any subsequent change in law anytime, and with that the litigant will get benefited with the same. So these questions are yet to be answered. Till the time they are not answered, it leaves a big room for debate. And it also reflects the impact of this ruling on future litigation, justice and legal profession as a whole. What are your thoughts on the same? Please comment down in the comment box, and I shall wait for your opinion in the comment section. Thank you very much.